Discretion is the legalized power to ignore the law without consequence, a system in which decisions are justified not by rules, but by authority. The illusion of law as rules. Most people grow up with a simple belief about the law, that it is a set of rules, written down in books, applied the same way to everyone. We imagine the law as something mechanical and impartial, a kind of social machinery. If you run a red light, the result is a ticket. If you pay your taxes late, there is a penalty. If you file a lawsuit, there are deadlines, disclosures, and procedures that guarantee a fair fight. In this picture, the law is a program, and the rules are its code. If the input is the same, the output will be the same. Simple, predictable, reliable. The very idea of justice depends on this promise, that a rule means what it says every time. But step into a courtroom or onto the side of the road after a traffic accident, and you learn how fragile that promise really is. Because alongside the rules, there exists a shadow power, an unspoken override that can erase the machinery of law in a single stroke. That power is called discretion. Discretion is the art of deciding not by rules, but by choice. It is the word that lets a police officer write a citation without evidence. It is the word that lets a judge excuse a lawyer's late filing while punishing a pro-se litigant for the same mistake. It is the word that lets mandatory rules become optional and rights become privileges, depending not on law, but on who holds the gavel. The system tells us that discretion is good, that it is humanity tempering rigidity, that it allows fairness in unusual cases. But the truth is darker. Discretion is the loophole that swallows the law. It is the velvet phrase that turns black and white obligations into gray areas of judgment. It is how rules that look clear on paper dissolve into fog when applied in practice. And this is no abstract problem. Discretion is not some theoretical concept for law school debates. It is the reason ordinary citizens walk away from courtrooms muttering that the system is rigged. It is the reason two people in the same situation can walk out with opposite outcomes. It is the reason a student can be threatened into signing a false confession, while the rules that should have protected him are quietly set aside. I learned this lesson twice. First at a stoplight, in the form of a minor fender bender that turned into a ticket. And then in a civil courtroom, where the stakes were far higher, the harm deeper, and the misuse of discretion far more corrosive. What ties both experiences together is the same poisonous word, discretion. The fender bender test. It was just a fender bender, the kind of accident that happens thousands of times a day across America. No one was hurt. Both cars were scratched, not destroyed. What mattered was who, if anyone, had caused it. The officer arrived, clipboard in hand, the embodiment of authority. But instead of carefully reconstructing the accident, he took the easy way out. He did not measure skid marks. He did not photograph the position of the cars. He did not ask for detailed witness statements. The work of evidence gathering, the only thing that could reveal the truth, simply wasn't done. And yet, at the end of his brief investigation, the officer handed me a citation. His explanation? Based on police discretion, I decided to cite you. Not based on evidence. Not based on facts. Based on discretion. That single word transformed the situation. Suddenly, I was the one burdened with defending myself. The officer bore no responsibility for his lack of investigation. The law, which should have protected me from punishment without proof, was bypassed. It is easy to dismiss this as a small thing, a traffic ticket, a nuisance to be paid and forgotten. But the principle is not small. It is enormous. Because if the system allows an officer to cite without evidence in a fender bender, it allows judges to rule without evidence in the courtroom. If it permits discretion to replace rules every day, it permits injustice in the extraordinary. Now imagine the alternative, a system without discretion, where rules guide the process step by step. Evidence first. No citation could be issued unless the officer collected photographs, measurements, statements, and makes his determination based on facts and merits. Fault matrix. A standardized chart would assign liability in common accident patterns. Neutral default. If fault remained unclear, the officer would issue only a report, no citation, no punishment, no presumption. In that world, doubt would protect the citizen. In ours, doubt punishes the citizen. That is the difference between law as rules and law as discretion. From stoplights to courtrooms. The fender bender was a small injustice. But later, in the civil courts, I encountered discretion on a scale that shook faith not just in one officer, but in the entire system. The case concerned my son's education and reputation. The rules were supposed to be clear. Arizona's Rule 26.1 named prompt disclosure of information requires full disclosure. No secrets, no surprises, everything relevant laid out on the table. Rule 37 named failure to make disclosures or to cooperate in discovery. Sanctions provides teeth, sanctions for parties who refuse to comply. Deadlines matter. Transparency is mandatory. That's what the rules promised. Opposing counsel had other plans. Responses came late, repeatedly. Documents required by law were withheld. And when pressed, counsel invented his own escape hatch. He rebranded mandatory Rule 26.1 disclosure into optional Rule 33, named interrogatories to parties' discovery. Rule 26.1 required automatic disclosure with strict timelines. Rule 33 allowed interrogatories, with delays, negotiations, and excuses. By mischaracterizing one as the other, counsel downgraded a clear duty into a matter of discretion. And the judge let him. Objections fell on deaf ears. When I pointed out the rules, the answer was the same phrase I had heard at the roadside. It is within the judge's discretion. Violations beyond procedure. The abuse deepened. Every request for compliance was met with delays, such as demands for meet and confer named good faith consultation certificate, procedural hoops designed to sap time and energy. Mandatory rights became optional favors, granted or denied at the whim of the opposing side and the silence of the judge. The rules were clear, the violations obvious, the harm undeniable. But none of it mattered, because judge had a discretion to override rules and destroy obligation. Nothing new under the moon. Sherlock Holmes once said, "There is nothing new under the moon." The same is true under the moonlight of justice. Deadlines missed, disclosures ignored, privacy violated. And yet, instead of strict rules to handle them predictably, fairly, automatically, we are told to rely on discretion. To trust that fairness and justice will emerge from the very power that bends fairness and justice out of shape. Fairness and discretion are subjective. The law is not. To accept that mandatory rules can be treated as optional, that rights can be bargained away, that violations of federal law can be brushed aside as mere tactics. The rule of men in numbers. Over the past year, we ran our own plain English audit of all 114 Arizona civil rules. We labeled each rule as mandatory, containing discretionary language or framework placeholder. The count wasn't even close. 97 of 114, about 85%, contained discretionary elements. And if you look only at the 108 rules that actually require a ruling, roughly 90% leave substantial latitude. This is not theory. It's the operating system of the courtroom. What begins at a stoplight ends in a courtroom, but the theme is the same. The law promises rules, but discretion delivers arbitrariness. The rules are written for the governed, not for the governors. The citizens must follow them. The judges and lawyers, through discretion, are free to interpret them away. This is not the rule of law. It is the rule of men, and it is the seedbed of injustice.